We turn now to the Information Regulator, Chairperson Advocate Pansy Tlakula, who joins us for more on that story. Advocate, good to have you, and thank you very much for coming on. I suppose quite apt in a sense, because you were previously in that organization and now you are on the other side, so you would have the benefit of understanding exactly what could have happened and hear how this could have been avoided. But let's start as far as the requirements of the Act are concerned. You have received a notification of a data violation from the IEC. We are getting reports that at least you've received 2 notifications.
Indeed, we have received notifications from the IEC regarding the security compromise of personal information of candidates of the African National Congress and the MK Party.
And what do you do then at this particular point in order to determine whether they are in compliance or not?
Let's start with what they have done and what is it that we are supposed to do. They are supposed to notify us, and they have done that. They are also supposed to notify the data subjects, and we believe they have done that because they have put a notice, or they were supposed to put a notice on their website informing the data subjects of the security compromise and its possible consequences. Now, on our side, we have to determine whether they have taken appropriate and reasonable technical and organizational measures to secure the integrity and the confidentiality of the personal information in their possession. So that's what we must do, an inquiry that we have to do. But for us to do that, they also have to give us certain information which they haven't provided. And we have now given them an information notice requiring them to give us that information. Yeah. And that information relates to the description of the possible consequences of the security compromise, right, and the measures that they have taken or intend to take to address the security compromise. Right. Have they even informed or advised the data subjects of possible measures that they must take, right, to minimize the impact of the security compromise? And if they know the identity of the person responsible for this security compromise, they must also inform us of that. They have informed us that about 204 data subjects of the African National Congress have been impacted by the security compromise, but they did not give us information relating to the data subjects of the MK Party that have been impacted.
So the data subjects themselves, they don't interact with the Information Regulator at all at this particular point. They would be interacting, I suppose, with whoever the data controller is. But here's what they are saying.
No, it depends. It depends. It depends. Nothing prohibits or prevents any data subject from lodging a complaint with the Information Regulator.
Because they are saying, look, I mean, it goes to the point of putting out the ID number of the president. Who knows what identity thieves will do with that particular number. And they have concluded that this is a violation of the POPIA Act. How complex is that process of proving that this is the violation of the Act?
It's not complex, because they, on their own admission, they have informed us that there has been unlawful access of personal information of data subjects. That on its own, the fact that they have notified us, means that indeed there has been a violation, prima facie, on the face of it. Now, for us, we have to then go in and determine, as I have indicated, whether the organizational and technical measures that they have in place are reasonable and adequate to secure the integrity and the confidentiality. Right. I don't want to prejudge anything, yes, but from what I heard, there is an official who was not supposed to have access rights to that information, who had
Right.
These are some of the things that we're going to be investigating to say who was given access to the system of candidate nomination. Was that person, did that person have access? If not, how did that person have access? This talks to the organizational measures that they have put in place to secure the integrity and confidentiality of the personal information. So we have not made any finding because we still have to do an investigation or an assessment after they have given us the information that we require.
So they're saying they're investigating two things. This is according to their statement. The circumstances to which the so-called unauthorized disclosure happened, and two, the identity of the source of the unauthorized disclosure. Does that give them a free pass, for lack of a better word? Does it absolve them of the obligation, the net obligation of being the data controllers and therefore being responsible for taking measures to keep the customer's information secure? In other words, can they say, well, look, it's this official, he had these credentials, he obtained the report and then released it. It's not the obligation of the organization.
No, that does not exonerate them. And I will repeat, we look into their organizational measures to determine whether we will exonerate them or not. At this point in time, we cannot make that call. All what we know is what they have told us, that there has been an unlawful access to personal information. And you must also remember, Tab, that personal information includes what we call unique identifiers, which is IDs. They have not even told us what kind of personal information has been impacted or has been unlawfully accessed. But a unique identifier being an ID, if that leaks, we do know, or if that information is compromised, we know the importance of an ID document or an ID number in South Africa and the information that that number on its own contains. So a security compromise involving an ID number, we view that as quite serious.
Now, very interesting in your request for further information, you are saying that we also want to know what steps have you taken further as protective measures for what could possibly happen now that the information has been leaked. Is there an expectation of something that could be done? I mean, the ID is out there. People, as you put it, people have got the IDs. They can access all sorts of information with that kind of ID. What protective measures could be put post the leak that has happened?
I mean, they must tell us what recommendation have they given to the data subjects that have been impacted on the measures that those data subjects must take to mitigate the possible consequences of the data breach. They haven't told us that. They have not even told us the description of the measures that they themselves have taken to ensure that, to address the security compromise. So I think we should give them time to investigate this matter and to respond to our information notice, which we issued, I think, either yesterday or so, or on Saturday. And after we have received that information notice, then we'll do an assessment ourselves and we'll make a call on the next course of action. And I'm sure we will keep South Africans informed in that regard.
Is there a relationship between the work that you will do then with them as an organization and the corrective action that they want to take in line with labor laws with their official? Or as the information regulator, you're saying, hey, Aridikeni, that's your thing with your employee. You deal with that. We are not there.
Well, they have to deal with their employer, with their employee, I beg your pardon. But there is a big relationship between us and the IEC insofar as their work and our work is concerned. Now they are publishing the voters' roll with redacted ID numbers. You'd recall that in the past they used to publish a voters' roll with the full IDs. And we made a representation to Parliament to say this cannot continue because of the uniqueness of an ID number as a unique identifier. And also, we are also doing work with them insofar as what political parties can and cannot do in using the personal information of voters for campaigning purposes. So, there's been ongoing interaction and collaboration between us and the IEC since the 2019 election. So, elections include two things that impact on our work. One, the protection of personal information of voters and of candidates. That has to be balanced against the free flow of information. And if you look at issues of disinformation and misinformation, they impact on the free flow of accurate, reliable information. So that's where our work and that of the IEC come together.
Advocate Tlakula, appreciate your time. Thanks so much for giving us this opportunity this evening. Information Regulator, chairperson there, Advocate Pansy Tlakula. Well, there you are. According to the Information Regulator, prima facie evidence that suggests a violation of the POPIA Act. But